see him.
Yeah, there he is, Judge.
Okay, got it. All right. Are y'all ready to proceed?
Yes, Your Honor.
All right, go ahead, Mr.
May it-
Manning.
Thank you, ma'am. May it please the court, Mr. and Mrs. Posner, after a long-term marriage, decided that they needed to get divorced. And on December the 3rd of 2018, they executed a marital settlement agreement. 11 days later, they entered into the final judgment dissolution was entered, which incorporated by its terms the marital settlement agreement that they had earlier executed. I made this marital settlement agreement as well as the final judgment, which incorporated as an appendix to the brief for the convenience of the court. Let me, if I may, talk to you a little bit about analysis of a marital settlement agreement. The purpose of a marital settlement agreement is to identify and equally divide the assets which were acquired by the parties during the marriage through their marital labor. The title to the assets so classified as marital is of no moment. In this case, the marital settlement agreement identified the marital assets and, with one exception, divided them equally. See page 3 of the marital settlement agreement if you want to, because that's where it appears. What you see on the page 3 of the marital settlement agreement is that the asset children's accounts, and by the way, that's an error. There's only one child involved here, an adult child. But the children's accounts for her purposes of education was valued at $416. Now, what is significant about my reference to the value of those children's accounts is that no part of the value of this clearly marital account was included in the value number assigned to the equal distribution of the marital assets. Now, the value number that was assigned to the equal value of the marital assets was approximately $730,355. You can see that actually appears on the schedule of the marital assets, but they don't include the value of the children's school accounts. It's equally divided between the husband and wife. Now, after the entry of the final judgment, the former wife made a claim for the children's accounts, apparently taking the position that the accounts were in her name and they should be hers. Now, that's clearly error we believe that's clear error on the part, but in any event, when the former wife made that claim for the accounts, the former husband commenced an action to enforce the transfer of the value of those accounts to the child. The trial judge decided that she had the jurisdiction to enforce, with which we agree, but she said, I'm really being asked to modify the final judgment, which incorporated the terms of the marital settlement agreement. Well, she really wasn't being asked to modify. She was being asked to interpret. And the question almost immediately is whether or not she interpreted the marital settlement agreement correctly. Let me pause for just a moment and say to you, if you look at the marital settlement agreement, you see an attempt to divide the marital assets equally with one exception. And that exception of the marital property was that portion of that marital property was to go to the child for the benefit of her schooling. What was inquired in this instance was not modification of final judgment, what was an interpretation of the marital settlement agreement to decide whether or not the clear delineation of the child's accounts, or the clear delineation that was not to be divided equally between the husband or the wife, but it was to go for the benefit of their child, whether or not it was error for the trial judge to say, without really doing it, that there had to be some sort of something extra for the child to be there. And therefore, she said, I'm going to have to modify the judgment to transfer the interest in the school plans to as requested by the former wife to, and that was not going to be done. The former husband, she said, had not pled a factual basis which would entitle him to modification, and therefore he was entitled to no relief. Now, that raises initially a conflict in the resolution of the initial problem which confronted the trial judge. Modification, she said, I will have to tell you, is required only if the final judgment is interpreted to mean there was no assignment of the school plans or the value of the school plans by the children by the family to the child. If the court correctly held that there was no assignment of school plan, then of course there would have to be a modification, but only in the event that you should affirm the disposition of the court that there was no assignment under this particular marital settlement agreement could recognize the child. Yes, sir. No, I was going to say, I suppose you were just clearing your breath. That's all right. Sorry, Judge. So the issue actually presented for resolution by this court is, was the trial judge correct in her analysis of the property settlement agreement, which held that there was no assignment? There was no assignment of the marital interest of the former wife in the property settlement agreement? If so, that she could claim it because she had it in her name? Now, keep in mind, this is a case where there is no dispute but that this child's school plan was acquired with marital dollars. It is clearly a marital interest. Now consider for a moment what was.
Aren't you on kind of the? Let me ask you this: you said it was earlier. It was of no moment whether it was marital assets or not.
A title was of no moment, Judge. I think I said title was of no moment in defining what is a marital asset. That's what
Oh, okay.
I didn't say it.
Okay. All right,
That's
well,
what
then
I was trying to
apologize for
use.
the but correct me if I'm wrong, and I might be, but you're kind of on the horns of a dilemma. So there's a big blank where it says amount subject to equitable distribution, and then it says that it's in. It seems to indicate it's in the former wife's name. If it's not subject to equitable distribution, then it's in the former wife's name. If it is subject to equitable distribution, but I guess I just want you to interpret. You talked about the fact that you created this schedule.
Well, not me, Judge.
What should have happened? What should the court have done?
Well, what it should have done was it did exactly what I did. Take a look at page 3 of that schedule. And page 3 of the schedule has a big blank where the child's school plans are described. The child's school plans are clearly valued. There's no question in anybody's mind, but that those school plans were bought during the lifetime of that child, and they were not marital assets. They were not non-marital assets. Marital assets are defined off from non-marital assets are defined in the last 2 columns. You look there, and there's the last 2 columns, big as life, and they don't include them in non-marital assets. Then over here, they do have them set forth. They did not include them in the value of the marital estate here, down at the bottom. Why? Because they were not concluding them as part of the marital estate, in spite of the fact that it's clearly a marital asset. If you look down here where it says total marital asset division, you even find out that they have exactly divided the marital estate between the two of them. $730,000.
Show me where you're looking again. Said total marital asset division. I'm still on page 3, right?
Oh, yes, sir. Come down all the way down to the middle where it says total net worth of parties. It's down at the very bottom. It's the 3rd and 4th column from the right. If you look over here, you'll see the 3rd and 4th column on the right. You'll see a double line under $730,335. That's what each of them got in connection with the division of this marital estate. Now, they did not include as part of that total value any part of the school funds that were bought by the children. And of course, we take the position why? They have children's accounts up there, big as life. They value the children's accounts, but they don't include it as either a non-marital asset or as a marital asset. Notice non-marital assets are very carefully described off onto the right-hand side. So now you have 2 types of assets described there, marital assets and non-marital assets. And you don't find these school things in either one. What you find there is a big blank with a description, child's assets. And that's who the assets were to go to. Everything else here represents a division.
So maybe that's where I thought of the horns a little bit. So it's the fact it's not a marital asset. And that this is by agreement of the parties. I mean, you could talk about, what constitutes a marital asset if that were to have been left to the adjudication of the trial court. But if you agreed, if the former husband agreed that it was not a marital asset, how can you ask a judge now to say, well, since she is doing something that I don't believe ought to have been done with this account that's in her name, I want you now to decide that it is a marital asset to be, and get an accounting. And if she's not going to give it to the daughter, I get half. But you just said, according to this chart, the parties agreed it wasn't a marital asset.
No, the parties did not agree to that. Look over there under the heading non-marital asset, and the value of the children's accounts do not appear there. Value of the non-marital asset.
But it also doesn't appear in the as a marital asset.
That's exactly right, Judge. So what did the parties, what you do then is you have to look to decide what is the intent of the parties with respect to the division of this asset. Now, there was never any question as to whether or not it was a marital asset. This asset was listed there as a child's account. It was divided for the benefit of the children, or the child. I keep saying children, when in fact, that's because they did it. They said children, but in fact, it was a child's asset. They said it was to be divided for the benefit of this child, not for anybody else. Now, I didn't say she kept
Mr.
it.
Manny, may I ask you a
Yes, sir.
question?
Yes, sir.
I guess in a sense, the parties sort of disavowed any interest in the education funds. They tend to, it seems that they agree it is an asset of the daughter. Is my question is the matter before us or before the trial court, is that a vehicle through which the daughter can either assert a right to that money? Where
Well,
the parents can basically say, distribute it to our daughter?
I think
Having
that
trouble
you're,
with the vehicle.
yes, sir, you're absolutely correct. That's what this agreement does. It says we agree that this asset should remain the property of our child. Didn't matter what the title was. This is these people are making a distribution of marital assets. We have agreed, the two of them have agreed that this asset shall be described as a child's asset. That's what it says.
Well, what
Child's-
is it fair to say that what they agreed to is whether it's marital or non-marital isn't the issue? We're not going to distribute it, whatever it is.
yeah, that's
So
exactly
we're
right.
setting this aside out of the distribution for the benefit of the child.
That's exactly right. You see, what you're doing is you're measuring the quality of the transfer itself. What did these people intend to do? And that is really my ultimate point. It is a function of the court to interpret this agreement. And I would
To
say,
If they
Right.
decided for it not to be distributed, then they're on their own. They have to argue and fight about it.
well,
They say,
and they
hey,
really,
court, we're not listing it as a marital asset. We're not listing it as a non-marital asset. We don't want you to adjudicate how this should be distributed. And now years later, the former husband is saying, hey, court, I want you to get involved again. And I want you to either, enforce the intent of my interpretation of the intent of the agreement, which is that it be, that it pay for my child's education, or that you now consider it something that should be equitably distributed.
well, I would agree with everything you say except one point. It says child's assets. These people entered into an agreement in which they describe these school accounts, and you can look up to the very top thing. It's the first thing it says, children's assets. They made a decision.
Wait,
to
what are
carry-
you
It
pointing
says
to?
children's accounts.
It says children's accounts.
accounts. I'm sorry, children's accounts.
Well,
Because
that's
that's what they were.
just a descriptor because these accounts are for the purpose of child's education, but it doesn't mean this. Anyway,
What
go on. Go
That's
ahead.
my point, Judge.
Well, let
Yeah.
me ask you this, Mr. Manny. What if they just not put this on the schedule at all? They just left it out because they decided between themselves, we're just setting this money aside for the children, and it's not even in here because we don't want the court to do anything with it. How is this really any different than that?
Well, for one thing, they described it specifically as being an asset of the child, their own child. That's what they've done. They said child.
Well, it
child's
doesn't say
accounts.
that.
It says child's accounts.
Yes.
And they did not make any attempt to distribute the value of that asset between themselves when they did with respect to every other non-marital and marital asset. In other
Okay,
words,
so they didn't want to distribute it. So they didn't really need to put it on the schedule, did they?
well, they didn't need to, but what they did, and that's why they did it. They wanted to make sure everybody would know that this asset would belong to the child when she became old enough, and when she became old enough to go to college and avail herself of its use. That's what they were doing. You can't really avoid the consequence of what they have done. If they hadn't done anything at all, then what you say is true. But they did something. They described that asset in connection with the division of all their non-marital and marital assets. And that's the only one which they didn't divide. And the reason they didn't divide is because they described it as a child's asset. And who else would ever use the school plan but the child? Now, that really raises another question. Why in the world would you have the result that this trial judge did, that in spite of the fact that everything here was intended to be an equal division of assets, they said, well, you can keep it, Mom, because it's in your name. makes no sense at all. It ignores the reality of being a parent. Being a parent means if you're going to describe a child's asset as or account, as you say, I accept use the word asset. If you describe it as a children's account in a division of assets, what in the world are you doing other than making it clear that that particular account is going for the benefit of the child? That implements a societal goal. What we want our parents to educate children. There's no reason to let this mother have this money, none whatever. There's no suggestion that it's a separate asset or non-marital asset. I would submit to you.
Mr. Manny, I'm sorry to interrupt, but you are at 15 minutes. You may use your time however you like.
Thank you, Your Honor. I would submit to you, it would be a clear error to allow this clear error of the trial court to stand. Thank you very much.
All right. Mr. Glaros?
Yes, ma'am. Thank you.
Good morning.
Good morning, judges.
Oh, it's good afternoon.
Oh, here. Yes, Your Honors, it is. Thank you.
Whenever you're ready, sir.
Thank you, Your Honors. May it please the court, Attorney Stephen Glaros on behalf of Cynthia Joan Posner, now known as Cynthia Joan Jordan. Your Honor, I just listened to opposing counsel's dissertation of the facts, and the confusion is that there's never been a finding that these children's accounts as listed were even a marital asset. He just stated that he wasn't the one who prepared the chart. I wasn't the one who prepared the chart, as I wasn't representing her at the time. All we know is that there's these accounts that are listed that are in fact shaded out. Are they shaded out because they were non-marital? Were they provided by a third party? Did a grandparent provide those? Is that why it was shaded out? The only thing that we do know where it says children's accounts on the schedule of equitable distribution is that it attached a statement, and it shows that the statement was attached as a source in that second column.
Well, and we also know that it wasn't distributed.
Correct. In addition, that statement that was attached to the sheet for their record for the source document shows that it was clearly in Cynthia Joan Posner's sole name. So for them to now come back and try to say, oh wait, we really meant to equitably divide that, just doesn't make a lot of sense when you look at all the facts of the case. If you look at the terms of the settlement agreement was very clear. The settlement agreement laid out specifically that, except as otherwise provided herein, the parties agree that whatever property he or she now owns or may hereafter acquire in their respective names shall henceforth be considered the sole and separate properties, provided same has been disclosed to the other party. Clearly, this property was disclosed to the other party. They used the statement as a source document, and it was in my client's sole name. So it's covered under the marital settlement agreement. In addition to that, paragraph 4 of that same marital settlement agreement, the equitable distribution of marital assets and liabilities goes on to the fact that there is an equitable distribution sheet. Does not mention anywhere in here that there's supposed to be a distribution for a minor child. In fact, there was no longer a minor child, as she was an adult and had emancipated and was not a party to this case at that time. But in that equitable distribution, under paragraph 4.2, it says the wife shall make an equalizing payment set forth in Exhibit 1 in the amount of $26,610 within 30 days. That math adds up to what they were saying the equalizing payment is. But then the next paragraph, 4.3, which Mr. Manny hasn't mentioned, says notwithstanding Exhibit 1, the wife shall make an additional one-time payment to the husband of $50,000 within 30 days of the entry of the final judgment. So how are we here now going to decide, was that $50,000 a part of buying out the children's accounts as listed? Was it for something else? We don't know, because the MSA is clear, it's unambiguous, and it states that whatever was in their own possession was their property. So the reason why we're here today is because Mr. Manny filed a motion to enforce that was denied. And if you look at the plain language of what he was requesting this court to do, he was requesting the former husband prays for the entry of an order of this court, directing the former wife to comply with the final judgment and make a disbursement to the daughter of funds held in accounts listed as children's accounts. Well, that would be a modification of the equitable distribution that was part of this final judgment, which we all know is well settled law, that you cannot modify equitable distribution. In addition to that,
It wasn't distributed, is his point, I think, isn't it?
Regardless, it's how it's titled is the equitable distribution. The asset is titled in my client's name, so there is no need to distribute it because it has been, as part of paragraph 5, deemed separate property. The parties, had they had an intention, I'm sorry.
No, go ahead.
I'm sorry. Had there been an intention for this money to be transferred to the child, there would be another specific clause in this settlement agreement that would say the column labeled children's accounts shall be dispersed to the child. That doesn't appear anywhere. In addition, in the opposing counsel's motion, he's asking for the wife to prepare an accounting of the 529 college plan. Again, that's nowhere outlined in the marital settlement agreement. What he is attempting to do is enforce a provision that does not exist in the marital settlement agreement nor in the final judgment. And the case law is clear. The trial court cannot change terms of equitable distribution. We cannot now go in and say, now this value is there, that it needs to be provided and split. We don't know why that $50,000 was provided. It wasn't challenged. It wasn't outlined as to what the specifics were. If the $50,000 that was provided was to provide some sort of reimbursement for other debts, or even a reimbursement for the child's that was labeled children's accounts. And more importantly, we don't know if it's a marital asset. I know Mr. Manny keeps saying it's a marital asset, but that was something that should have been determined prior. We're here today to see if this judge did something incorrect, and there's just nothing there to show that she did something incorrect. So our position is that the trial court has done what they were supposed to do. They failed. They purposely did not modify the equitable distribution. They were unable to enforce a provision in the marital settlement agreement that does not exist. And therefore, these assets belong to the person who owns it pursuant to their own signed settlement agreement, as there's clear and unambiguous language that allows for my client to retain that asset. And quite frankly, that if it is a children's account, we might be premature here. Maybe the child would get money to go to school at a future date. There's nowhere in here where it just says that this child is going to just receive this lump sum of money and be able to take it, whether she's in school, not in school, if she chooses to go to school. It's presuming way too many facts that were never introduced, that are not part of this matter. And the main basis of this is whether or not this court overstepped her bounds or did something incorrectly. And I don't think that this court can find that based on the four corners of all the documents presented, including her order, which specifically went into the case law that she relied on to verify that she was correct in making her specific findings. Thank you, judges.
Okay, is that it? Are you
Yes, ma'am.
concluding? Okay, all right. Thank you very much. All right, Mr. Manning.
Thank you, Judge. You know, you ask yourself the question, why would you prepare a schedule of equitable distribution were it not for the purpose of defining marital and non-marital property and agreeing upon the distribution of the assets of the parties? That's why I say this was a marital asset. The parties recognized it was a marital asset, or they wouldn't have included it at all. If it had been a non-marital asset, they would have included it under the heading non-marital asset. They have 4 columns on the right-hand side of their schedule, in which they have the first 2 columns are for marital assets, the second 2 columns are for non-marital assets. They have refused to include it in either of these categories. So what we have left is an assignment of the interest that they had in the property to the children's assets. So it no longer is a non-marital asset, if it ever was. It's no longer a marital asset, if it ever was. It now belongs to the child. What these people did with this schedule of equitable distribution was to take an asset that they assigned to the child, whether it was non-marital or marital, no matter what it was, they've assigned it to the child. It's for her benefit for the education. You look down at the bottom of this agreement, same page, say 3, they have equally divided all of their marital assets. And of course, there is an unequal division of the non-marital assets.
How do you square that with the separate property provision in the body of the settlement agreement?
Because they in that particular instance, what they're looking for, Judge, is for property that neither knew about. In other words, they're trying to get rid of that. They have done their best they can in this schedule that you're looking at, not in the body of the final judgment, in the schedule of equitable distribution. They have done the best they can to accurately identify both non-marital and marital assets. And what they have done is they have excluded the children's accounts from the value of either marital or non-marital assets. The question is whether or not this represents an effective assignment of whatever interest that they may have had, whether it was non-marital or whether it was marital, to the child. I would submit that it has. I submit that there's no other reason to have this type of schedule of equitable distribution, and the final judgment incorporates this particular schedule. And I think you must find that the trial judge has erred. You know, not to find that, he does 2 things wrong. One, it disimplements, if there's such a word, the societal interest in having the child educated. That's number one. And number two, perhaps even more important, it ignores the function of a schedule of equitable distribution, which is for the division and identification of marital and non-marital assets. Thank you, Judge. I appreciate your attention.
Thank you. Thank you both. And that concludes today's session.